Hello, hello. Okay. This is 3:08, so I think we will start. And I know a lot of people are still out there enjoying the networking break, so hopefully you'll trickle in. And welcome everyone to this panel on invasive spyware technology and their implications. My name is Elizabeth Chen Hao. I am intellectual property.
Recording in progress.
A little bit behind. My name is Elizabeth Chen Hao. I'm an intellectual property attorney. I do cross-border IP issues, mostly between the United States and China, and in practice in a variety of roles. I started in law firms, went into in-house for a good number of times, and then came back to law firm. And also a long-term MBA member. Very glad to be here. And we have here a group of very knowledgeable panelists, extremely knowledgeable. And to, like I said in this description, I would like to give this 360 view. So we have a technology, cybersecurity specialist from engineering perspective, Angela's Kuronitis from Georgia Tech. And we also have cyber law specialist in Korea, Professor Hong Yong Kwang. We have the general counsel of the product company of one of the most famous spyware, Pegasus, Shmuel Sunray, who unfortunately can only join us by Zoom because the escalating conflicts in the region. And last but not least is Mr. Cyrus Vance, who is a former Manhattan district attorney, and he will be telling us from the government's point of view what should be done in terms of regulation and future regulations in this area. So a little bit of background about spyware before I hand over to my panelists. So we have been reading, their invasive technologies have always been with us. Every time the technology comes up with a new technology, and we've been hearing complaints and horror stories, and what it can do to humanity. But invasive technology is a category of its own. We have seen similar variants of that. Adware, nobody invites adware. When they drop it onto our computers, onto our phones, and we get messages from people that we don't know. And we also hear things such as like face recognition, which is getting a little closer to on the law enforcement side. But I think the one we want to focus on, Pegasus, is kind of a category of its own. Not to say that this is the only product in its class. There are very many similar products, and they're all coming up. But if you're a casual reader in the press, this almost works like magic. So we've been living with malware for a long time. Usually it comes in the form of email in attachment. You have to open, you have to click before it lands on your computer or your phone. But Pegasus is the so-called zero-click, almost works like magic. And according to reports, you can receive a phone call, for example, on WhatsApp, and the call you need to answer, actually, even though there's a fairly good log with all the incoming calls and messages on WhatsApp. So this kind of technology, they can erase the log. And then they will play itself onto your phone and slowly migrate into the rest of the phone and maybe migrate to other devices. So to open the discussion, as Angelos, can you give us a little bit more background about spyware from the technical perspective?
Yes, thank you. Hi everyone, thanks for coming here and having me here. So we jokingly refer to spyware as uncooperative remote administration tools. They're really the same kind of tools that you'd use, well, let me back up. Conceptually, they are not much different from the tools that you would use to remotely access your computer when you're traveling, right? You establish a connection, you're able to conduct some operations, transfer the data, access the data that's there, and so on. It may be the phone rather than computer, but fundamentally, a lot of the core functionality wouldn't really surprise you if you think about it. What makes it interesting, the spyware, so we call them implants, themselves really is the ability to operate stealthily, right? And that's kind of what concerns most people, the fact that you don't know that it's there. But an implant or a piece of or a spyware, it's really a program, is really only one aspect of a complete cyber operation, right? So it's not like I look at David there and say, oh, I'm now going to make the spyware appear on your phone. There's actually a whole sequence of events that starts from knowing who the target is and specifically knowing concrete identifiers for that target, right? So an identifier, think of it as an address of some kind for that person, some way in which a computer can reach out and touch that person's device or devices. It could be something like an IP address, which we're all familiar with. It could be a phone number. It could just be a LinkedIn profile, right? And what identifier you start with depends to a large extent on what means you would use to get the spyware, the implant, executing ultimately on the target device, because that's the goal, right? I have the spyware and I want it to execute on David's or Elizabeth's phone without them knowing it, hopefully. So you start with identifying the target, doing reconnaissance. Traditionally, you determine, after determining what the software that's executing on that device is, what version, or product, then you identify vulnerabilities on that, ways that you can confuse the device such that the software can execute. Then you build the exploits, or you may have pre-built them, and we'll return to that in a second. Then you throw the exploit, that's the technical term, which, if successful, it will land on the target device and will start executing without being noticed. Then that, typically what will land is a very small piece of code, not the whole spyware. It'll be a first stage of exploit that will then reach out over the network and download the second and maybe a third stage of the implant, just because sort of limitations of how big a first exploit might be. Just to give you a sense, the first piece of data that you might send as part of exploitation could be as small as 100 to 200 bytes. Whereas a full implant can be many kilobytes or even megabytes, depending on the functionality. So we're talking about substantive programs there. And then that implant, once it has embedded itself in the device, it needs to escape from whatever constraints it has found itself in. So browsers, for example, are typically sandboxed. They're limited and limiting in what can happen in those processes legitimately, precisely for to avoid unnecessary or increased exposure when a device does get compromised. So the implant will typically go through a series of privilege escalation steps, trying to escape the sandbox, compromise the operating system, embed itself, make itself persistent. It will also try to communicate with the controller, presumably over a network such as the internet. And that by itself introduces a lot of complexity, because you can't just have it contact you on your, whether it's NSO or anybody else, or even an intelligence agency or the FBI or whoever. It won't talk directly to you. You need some kind of infrastructure that cannot be identified easily by the defenders or the target, that it cannot be attributed necessarily to the controller, to the owner of the, or the operator of the spyware and so on. Then there's the exploitation phase, during which intelligence is extracted from the device, whether it is files, information that is resident, or things like turning the microphone on, or getting the GPS coordinates on a continuous basis, whatever the mission is. And then we go through a cycle of stealth, persistence, potentially lateral movement, so moving from that device to other devices that have some kind of trust relationship. So not so much for phones necessarily, but if your personal computer or your workstation at your firm gets compromised, typically the first thing that will happen in a Windows environment is an attacker will try to laterally move to the domain controller, because then they have complete control of the enterprise. And then at some point the operation needs to end, and there's a cleanup phase as well. All of these can take a long period of time because there's a lot of tradecraft. It's not just a matter of having a tool and having a gun and pulling the trigger. There's a lot of preparation, there's a lot of intelligence, there's a lot of planning, a lot of contingency, especially if you care not to get caught. And the tools for each of these and tradecraft for each of these is kind of well known out there. You can go on any open source repository and get each of the tools. You can get first-class implants. They may not be as nicely packaged or as nice a GUI as some of the commercial offerings, but the core functionality is really there. There's even leaked spyware or implants from intelligence organizations whose implants have been caught and have been published by antivirus vendors and so on. And people have reused those things. So what really matters is not so much the code itself or the implants. There are two things that matter. One is the tradecraft, knowing how to use the tools. And the second is the magical bits that cause the program to run on that device, the knowledge of how to exploit the vulnerability on a remote device, right? And that's what Elizabeth was referring to as this, the zero click, which is finding a vulnerability in some part of the communication stack of a phone that, if successfully exploited, does not give any indications to the user, right? So it could be a text message or an iMessage that the iMessage subsystem on your iPhone sort of gets confused by and starts executing foreign injected code before it actually gets to display, hey, you have a new message. Right? I mean, that's really all that's happening there. It's not much. It's complicated, but the basic principles I teach in my intro to cybersecurity class, right? And my students build very simple vulnerabilities on toy programs might. Now, having said that, the vulnerabilities for a device like this in the black market, they go from $500,000 to $1.5 million, depending on how many are available. So that's what really differentiates some of the commercial tools, right? Because you're not going to find in the open source any of these vulnerabilities sort of freely available. You're going to have to go buy them and figure out how to use them, how to throw them, and so on. And I guess to conclude this long diatribe on the technical side, I think one of the kind of differentiating factors and one of the points of worry for a lot of people for commercial spyware is the fact that they do all this work on a continuous basis, finding vulnerabilities for devices that are very popular and are very likely to be used by legitimate and illegitimate, depending on your point of view, targets or users. And they make it very easy to point and click, right? I mean, you point at the target, click, and things happen. So, it's one thing for an intelligence organization working for a sovereign government with all the resources and the authorities to use these things to develop these capabilities and exercise them under proper scrutiny. It's another to potentially give, pardon my French, an idiot, a fire and forget sort of capability that, yeah, they will eventually get caught and evidence from people, news articles that appear, but in the meantime, it can cause a lot of damage. I'll stop there.
Okay, well, thank you for that quick, brief overview of spyware from a technical point of view. So next I'll go to Cyrus Vance. Cyrus, I know you're now in private practice at Baker McKenzie, but prior to that, you handled a large number of very well-known criminal cases. I'm sorry we won't have time to talk about Charlie Weinstein, which you're best known for, and I still see you on TV from time to time. But from that point of view, as an enforcement, on the enforcement side, this spyware, the fact that you can have complete access to the target's data, there must be a joy to you from the prosecution side, and in spite of all the other bad things we've heard.
As well, thank you, and thank you for David for inviting me to be here. It's great to be in Seoul, which is my first time here. So I was the Manhattan District Attorney, which is a very large prosecutor's office in New York City, which has about 600 lawyers and handles about 100,000 cases a year. And they're all criminal cases. And over the 12 years that I was district attorney, between 2010 and 2021, we obviously were confronted with the reality that crime was occurring and recorded and conducted through digital means, and every crime has a digital fingerprint. Simple crimes and murders, everything is in some way today connected to a device which requires digital access. And so for us, it was, and for law enforcement generally, it is essential, although obviously there's a political debate as to whether law enforcement should have these tools. But one needs to understand that as criminals have gone online and are operating off encrypted devices, cell phones and the like, that you can't combat crime and you can't build cases, particularly complex cases, unless you can access the information that's stored on the digital devices or in computers in their homes. So we were confronted with a changing environment in Silicon Valley. There was a point when Silicon Valley responded to subpoenas from government agencies for access to devices enthusiastically, believe it or not. And then the Snowden incident happened, which revealed real lapses in security and perhaps honesty in the American intelligence system. And the technical community immediately did an about-face and started to encrypt its devices by default, which then meant that we were no longer getting the cooperation of the cell phone companies who manufactured these devices, into whom we would have to go back to open the device with a court order. So we started to get into the business of examining what technologies, spyware and other, could get us access to these devices. So a long way of saying that spyware, in one sense, from the government sense, has become, I think, an important and essential tool. There in the United States, certainly in our office, it's not rogue DAs going out and using spyware. We would never open any device, or try to open any device, without going to the court first and asking for a warrant, outlining the reasons why we believe this device, or these devices, contained evidence that we couldn't get any other way. So in one sense, it's essential for protecting our country, protecting our communities, to access communications that criminals are making and recording on their phones and otherwise, and you've got to figure out a way to get into it. And one way is spyware. I went to Israel. I met with companies in Israel and was given a preview of spyware. I didn't buy it for the office because I honestly was not comfortable. Not that I was being morally upset, but I thought it was very interesting technology, but I was cautious. I made investments instead with a company like Cellbrite. Cellbrite is another Israeli company whose technology is that which we started to use early on, and our office developed cyber competence a long time ago because of a conscious decision when we knew what was coming. And Cellbrite gave us the ability to essentially crack encrypted devices, not certainly every device. It turns out over time that if we seized 100 Apple devices, iPhones, or iPads, that using Cellbrite, we would get into 50% of them. But you couldn't tell when that would happen. In other words, you might be able to get into it by running the programs that Cellbrite had in its programs. You might be able to get into that device in a day or 5 years. So that in itself, I think, just gives you an indication of some of the challenges that law enforcement still faces when we have encrypted devices that are encrypted by default. We operate in the criminal justice system under rules of statutes of limitation, and those vary depending upon the severity of the crime. But if the crime occurred 3 years ago and you access the device on 2.5 years later, you may not get into that device before the statute of limitation runs out, and therefore before your ability to prosecute that case may be lost. Secondly, when we can't get into devices, those devices are related to real people and real victims. Child sexual assault, terrorism, international money laundering, rape, robbery, murder. Every device that we seek to get into, presumably, there's a good reason for it, and it's laid out to a judge in a search warrant. Judge signs the warrant, but if we try to crack the phone, we will get in 50% of the time, but 50% of the phones we don't get into, those aren't relegated to minor cases. Those could be any number of cases. And we've had murder cases where we were able to finally get into the phone literally weeks before trial, although the case has been pending for several years, and that's a very good thing, but it shows how difficult the timing can be. So, very simply, I actually don't think law enforcement's, the importance of this for protecting our communities in the hands of law enforcement, at least prosecutors who go to judges for search warrants, is really a debate. The question is, how do we regulate spyware, both within the United States and globally? Because the challenge with spyware is that it's being used in ways that are violating human rights in many countries. And there's allegations that it's being used in the United States by the United States against the United States citizens. So I'm sure we'll have a conversation about what the global situation is. But A, it's essential for law enforcement, and B, there's no easy solution on how we deal with this issue, both within the United States regulatorily and globally.
Thank you, Cyrus, to give us that perspective. So we hear from what you just said, the good uses this technology can be put into. The problem is, I guess, especially with Pegasus, it was found that it was used against opposition leaders, journalists, government officials, so they've been turned on to not the bad guys, but potentially, well, we should say these are the good guys, people who serving positive functions in society. So I guess the question, Shmuel, for you as a general counsel of the company that produces product, should there be, what kind of steps do you take to monitor who you sell it to? We see now from what Angela and Sarah said, that there are real merits and technology advancements in this product. The question is, it needs to be put to good use. So the selection of targets are very important. So what does NSO do in this regard?
Thank you, Elizabeth. I hope you can hear me well. First of all, I'd like to apologize for not being here physically. As you know, Israel is going through a very traumatic time. I've been going through funerals and seeing sights of children being decapitated and women being taken hostage and elderly ladies being burned alive. So I apologize if I'm a little bit emotional, but these are difficult times, and as such, I wasn't able to participate. But I felt it important to go and discuss this important issue, which I think I can't even separate it from what's going on now in Israel, because I think, as Cyrus was mentioning, these are the type of uses that these tools were developed for. Once the technology, and Angela talked about the technology and the risk and the complexity, and I'll relate to that into your question in half a minute. But basically, once the tool was developed as a need that came out from law entelligence agencies and intelligence agencies, once we went under what was called going dark, once they didn't have any visibility beforehand. There was possibilities of using wiretaps and going through the MNOs and getting the details and under conventional matters. But once the tech companies came out with end-to-end encryption, which is of course a great contribution to society, but it also poses a great risk to society, because not only we could feel confident that we can correspond with each other and our friends and our families, but also the terrorists, the pedophiles, the drug lords, the human traffickers are doing as well. So as such, there is very much a need, and we see this being worldwide. But I think that what you're addressing, Elizabeth, is the question is there's always the balance between the tool and the legitimate uses of the tool and the potential misuses of the tool, which is true for any type of tool, right? It's true for the phone itself, right? Also a telephone, and then encryption is the same way. It can be used and it can be misused. So the counter to that, which is to have tools like Pegasus, also, and it's not a tool is not inherently good or bad, right? The tool is a tool, it's a program, it's a software, and it's developed and designed for a good usage, but it has the potential for having bad uses as well. And here the question comes up, which is something that we've been dealing with from the establishment of the company, of how do we go and ensure, as much as we can, as a private company, that the uses are being done legitimately, lawfully, under the right rule of law, under the right, and I think Cyrus mentioned a bit about the rule of law, and with the right players, because there could be, when we talk about rule of law, the rule of law that Cyrus is defining, I think we can imagine that in certain countries that we won't name, that the rule of law is a farce, and basically even if they have a Supreme Court that's basically the nephew of the leader and signs off on everything automatically, that is not considered a rule of law. So what we did is and this is something I think that we're very much kind of pioneers, and I think this is something that we've been also trying to advocate to become more of an international norm and under international regulation. We can talk about that maybe a little bit later, Elizabeth, about how to go and form this into some type of international regulation. We put into place under the United Nations Guiding Principles for Business and Human Rights, which is a very important document, because this is a document that basically is the first time that acknowledges that there's corporate responsibility for human rights on companies, not just on governments, because conventionally you would think that human rights is really an issue that governments need to deal with and protect its own countries and its own civilians, etc. But ultimately, the UNGP came out, and not only the UNGP but other documents as well, talking about corporate responsibility, which is of course very important. And such corporate responsibility also applies to companies that sell such tools to governments, and the respect of human rights that is inherently put upon companies is something that companies should be dealing with. How do we deal with it? And again, I'm talking about companies, and I think that a very important part of this is governments themselves, right? I'm saying we're not saying, and the UNGP is not saying that that we should go and rely on governments, but I think that we cannot rely only on companies, and that's why I think this is something that also should be dealt with on a governmental level, and repeating myself, on an international regulatory level. So what we put in place is mechanisms, first of all, as far as who we sell with, how do we sell to? We sell, first of all, we only sell to governmental entities, that's obvious, and this would never be placed in private hands, and what Angelos is describing is pretty terrifying, that, basically, his students in Georgia Tech, can go and develop maybe some non-sophisticated tool, and I have to say that this is something that terrifies me, and I think should terrify us all, that, this is something that who knows what hands it could be on in private hands, and we've been approached by different private entities that be willing to pay an enormous amount of money, but that's something we'll never even think to consider. It has to be only government agencies and only responsible government agencies. And how do we determine what's a responsible government agency? So here we put in place a full due diligence program, which is very similar to AML or SCPA or other mechanisms I'm sure you're all familiar with. And we basically do due diligence on the end users, on the countries themselves, right? It's which is I think pretty unique, because we check the scores of the countries under different international rankings. We take intelligence, business intelligence groups that do due diligence, either ASIN or UMINT, discussing with people on the ground, people who are ambassadors there, NGOs, etc., to understand the record, not only of the country, but of the specific agency, as far as whether it's a responsible agency, whether it has respect for human rights. We also check the rule of law. We check whether they have the systems in place, that it's basically that there's independent warrants or other type of legal mechanisms to ensure that this is being done correctly. We train, we do it, and there's a lot of things, because of the time we won't go into the full program, but there's a lot of things that we put into the program in order to ensure that this falls into the right hands. But ultimately, since we don't operate the system, since we have no visibility to the data, since we're not an intelligence agency, and we don't want to be, and the customers, of course, we don't want to operate any system. So, the monitoring is a bit of a challenge, and as such, we are very much dependent on reports of misuse, either by NGOs, by the press, by whistleblower mechanisms we have in place, which have been proven very useful. And this is, I think, something that's very unique, is that when there is an allegation of misuse, and Elizabeth did mention that there have been different allegations of misuse that some of them are basis after investigation that's never happened. It wasn't our tools, it wasn't our system, or even if it was, sometimes it was other legitimate judicial overview and good reasoning, but not evading responsibility. Sometimes cases there are tools have been misused, which is horrible. It's something that we totally condemn. And as such, we have an investigative process in place to go once there is such an allegation, we investigate it. We need cooperation from the customer. If the customer does not investigate, it does not cooperate, that itself is a reason, and we shut down the systems. They have to provide us their logs, their audit logs, that we put in anti-tampering mechanisms to ensure that this is an investigation, that they'll be giving us the true documents and the true evidence. And if we're not convinced, and this happened many times, at least 10 times over the past 3 years, that we're not convinced that the system was used as it was supposed to be used, and we put in our contracts very clear mechanisms, very clear directives as far as what's legitimate use, as far as international human rights and what is considered terrorism, and a lot of other issues that it's unfortunately we don't have time to go and elaborate upon them fully. But once we reach a decision or reach a conclusion that there is no legitimate, there has been a misuse, we shut down the system. We have a kill switch. We have the ability to shut it down remotely, and we do so. Of course, we do so. It's sometimes it's even worrying that when you do so, because what worries us, but doesn't change our mind, is some of these customers we see after we shut down the systems that they get these similar systems from other players that aren't as conscientious as we are to human rights, and if we're looking at it in a global human rights perspective, I'm not sure what's better, but of course we won't be complicit in any type of abuse of human rights and misuse, and etc. And so we're very serious about it. And I think that ultimately, and going to your question, Elizabeth, and I'll say and repeating this, and trying to repeat this a third time, we're doing what we can as a company. I think we're doing a lot. I think we're doing things that other companies that we don't know if any other companies in our field or in other field that have such mechanisms in place. But I really believe that this is something that should be dealt on an international level, either through export control regimes or in some type of international convention like similar to the NPT or other type of regulatory regimes, because ultimately I think there should be some type of international overview of what type of customers should be eligible to such systems, what type of overview internationally is done over the systems, what type of sanctions should be done to countries that are misusing such type of systems, etc. So we're doing our best as we can as a company, but I think that it's not enough, and I think without governmental support internationally, bad players will still be out there, and things are, it's a problem on a global level. I think we always use the Peter Parker rule, or Peter Parker's uncle rule, that with great power comes great responsibility. We truly believe that this is tools that have great power, and using them is great responsibility. And we are very much conscientious to that, and we call upon all players in the field to go and take that into consideration. So I'm sorry, it's a long-winded answer to your short question, Elizabeth, but I wanted to give the overall picture.
Yeah, thank you for sharing. It's reassuring to know that you have the ability to shut it down, and so it's doing some kind of monitoring on its own. And we're going to deep dive into whose responsibility, what technology, for this technology, right? The technologists themselves, the government, and the company. But before that, we're going to turn to the Korean perspective. Professor Huang is going to tell us what has happened in Korea and what are some answers that you have for us.
Thank you.
That's okay. Good afternoon, everyone.
I'm An Kwon, professor at the School of Cybersecurity in the Korea University. It's my pleasure to see you in face. Today, I'd like to discuss the use of invasive spyware by the South Korean government and the ongoing discussions surrounding online surveillance and search within this country. Over the recent years, the international community has been deeply concerned about the government's using spyware for surveillance purposes. In context of South Korea, an incident in 2015 raised eyebrows. Korea National Intelligence Service, like as the CIA in the United States, faces allegations of using spyware for illegal surveillance. This came to light when an Italian security firm called the Hacking Team experienced a security breach, revealing a client list which included the NIS of Korea as a client. This triggered questions within Korea. Did the NIS legally buy this spyware? Did they actually use it? And if so, who were the intended subjects? According to Korea legislation, Protection of Communications Secrets Act, government agencies require authorization to purchase surveillance tools. However, there is an exemption for agencies if deemed essential for safeguarding national security. In response to the controversy, the NIS provided a statement saying they used the spyware mainly for keeping tabs on North Korean operations and for cybersecurity research purposes. They firmly denied any claims of spying or ordinary citizens or interfering in election processes. Ultimately, while it was concluded that the NIS's engagement with spyware did not breach the law, it seriously damaged their reputation. This raised considerable concerns about illegal wiretapping and surveillance targeting the Korean citizens. In South Korea, there is a growing concern about online surveillance and searches. Yet, there's also a growing discussion about their necessity, especially given the challenges in gathering digital evidence. In Korea, we have a system where you need a judge's permission or a warrant to execute a search and seizure of digital evidence. This was solidified in 2011 with the Criminal Procedure Act, setting clear guidelines on the search and seizure of digital evidence. However, there are challenges. If the person being investigated doesn't cooperate, it's hard to collect evidence. What's more complicating is the shift to cloud storage. Information can be modified or erased instantly. So, during an investigation, there is a potential for the alteration of evidence. As we increasingly store data on the cloud, where data is scattered around different platforms and locations, it's getting tougher to locate and analyze data. On the other hand, when we think about spyware, its application in online search can be effective, especially in gathering digital evidence. This becomes apparent in a scenario when the evidence is stored remotely or spread out through cloud computing. There's also the challenge of evidence being tampered with, deleted, or encrypted before any formal investigation can take place. Given the digital age we are in, many criminal activities where they are just being planned or already underway are happening online. This has caused a noticeable rise in cybercrimes. Considering this trend, some scholars and experts even suggest that we need to incorporate new investigative techniques, like using spyware or other hacking methods as part of online searches. Furthermore, serious crimes related to national security or acts of terrorism can be detrimental to the nation's stability once they occur. The organized and covert nature of these crimes often make traditional investigative methods ineffective in evidence collection and in proving the criminal intent. In 2020, South Korea recognized the urgent need for introducing online searches in investigations concerning digital crime targeting children and teenagers. Main platforms utilized for these crimes, such as Telegram and the dark web, presented challenges due to their untraceable IP addresses, encrypted network packets, and their overall reluctance to assist in investigations. As a result, online searches were proposed as a potential solution. In light of these considerations, the National Office of Investigation is currently considering to introduce lawful hacking techniques in investigations. However, the use of hacking techniques for online searches should be approached with caution. Online searches involve secretly accessing someone's IT system, exploiting its vulnerabilities, installing spyware, and gathering information. This approach allows for the potential collection of a vast amount of information without limits. When you compare this to traditional methods like wiretapping or physical searches, it's evident that these new techniques can be profoundly infringe upon an individual's basic rights, given that the surveillance happens without their knowledge. There are significant risks associated with the installation of spyware. There include potential data loss and data leaks. Moreover, not only can be stored information on a target computer be accessed, but there is also the capability to collect data being transmitted in real time. This signifies extensive state surveillance in cyberspace, which might suppress individuals' freedom of expression. Furthermore, such actions can potentially limit an individual's right to control their personal information and may compromise the confidentiality of their communications. With cybercrimes getting complex and advanced, it might seem that our government agencies need tools like spyware. However, using these tools can step on people's basic rights and might not always follow the right legal steps. If we decide to use spyware, a robust system must be established to ensuring its lawful use. An essential aspect of this system would be supervising by the misuse of information. The supervisory body should be independent, have clear authority, and be transparent in its activities. Thank you very much for your attention.
Thank you, Hong Yang, for sharing the story from South Korea. So I think now we're getting to the portion, and all of you are welcome to jump in at any time. So basically, I was identifying the three areas that requires monitoring: the targets, right, and the buyers, and the throw. I guess we can, people want to know the buyers and the targets we already discussed, who should be allowed to have access and who should this software be applied to. But maybe we can start with a vulnerability, because there are 2 lawsuits filed by Silicon Valley companies, and then from what I can tell, they use causes of actions like computer fraud or California computer data access, breach of contract. Basically what I hear is tech companies crying that it's a crime to find the vulnerability and to exploit the vulnerabilities. So that's like a third angle. Right? So tech companies saying they are also victims in addition to the real targets. So how should we start?
I have a technical question, which probably spills into the bigger question. When you are doing a wiretap, the law enforcement officers are required to log and limit what they can hear by turning off the tap when, for example, a spouse comes in the room and we're talking with a lawyer. The Supreme Court some years ago in the United States decided that prosecutors needed to be more specific in terms of what they were actually seeking in a phone, for the very reasons that the professor identified, which is that the phone can have your whole life on it, and you are looking for theoretically specific evidence of the crime. So my question for our friend in Israel and for you is, can you limit what you get when you are in a phone using spyware? Can you be discriminating and, in that sense, remove some doubt about the appropriate limits that law enforcement can use?
Spiro, you want to go first?
She's running on the screen now, we can see you.
Questions to me, I'm sorry, I had a very hard time hearing. I think when I managed to hear, just to go and make sure that I'm talking about the right thing, is whether, because of the breadth of potential of collection of the system, whether there are ways to limit it. Is that?
Exactly.
Okay, wonderful. So the answer is definitely yes. Okay, definitely yes. So the system itself, technology, and Angelos can explain this a lot better than I can. Right? Technology is technology. It enables you to do anything that you can. Right? And the system is designed accordingly. Yet it's designed also to be sectoralized. I mean, basically, like and first of all, since it has a very long, broad potential of collection, the system itself has to go and has in itself, the users have to fill in the different parameters. We have part of the system. There's like a warrant, with a warrant-like application, which basically times that you have to go and put in the details of what it is that you're allowed to go and listen to or collect, etc., either according to time or according to what type of messages. It could be to different IMs, right? It could be, for example, you can go and collect the calendar, right? Because it's important to see where you'll be meeting, but not to collect the contacts, because the contacts maybe are very broad and have also personal contacts, etc. So it's part of the proportionality that I think that Cyrus is also very dealing with as far as the U.S. So the system itself, as I said, the technology is broad, but within the system we put in the parameters. And for the users, and of course, part of the doctrine and training and discussion and contract, etc., with the customers is based upon the rule of law in such country and the limitations. So the short answer, the short answer is yes, the system has these capabilities. The long answer is that the system is a very generic system, but it has in itself the tools to go and work with the users to limit it according to the use case and the law regime of the specific customer.
So to perhaps paraphrase in some ways what was said, such systems are often, but not always, speaking more generally about the industry, they're designed to allow well-intentioned users to have a proper chain of custody trail. But it's very hard, if not impossible, to have such a system that will prevent a less than ethical user from exceeding their authorities, which of course, honestly, it's the same for the traditional wiretaps as well.
Yes. But I think one thing is clear. And I think it's also from your question statement. Ultimately, the technology is not the solution. The technology is limited in the amount of selective uses it can provide as a technology. And the emphasis, and that's why when I talked before about also our compliance and the regulatory, ultimately it's the users, right? We said it has to be the responsible users and etc. But also responsible users have potential of misusing, or there could be an irresponsible user within the responsible users, and that is something that needs to be dealt with on a human level, right? Either as far as the training, the monitoring, the auditing, the threats, etc., rather than on technology. Because I think if there was some type of mechanism or some type of algorithm that will basically identify misuse or within the system, or then we'd be happy to hear ideas. We have certain things in place, as I said, putting in the different abilities that the program and setting up the systems according to the customer's uses, needs, and laws. But ultimately, misuse is a human misuse, and that's what we need to emphasize on to make sure that doesn't happen. Beyond, and I think that's where the real risk is, and technology cannot give a full answer to that.
Cyrus, I have a question for you. I think what your question shows that as government has some kind of self-regulation, so there's certain information which you don't think you should have, even if you to have this tool. But at the same time, what is the government's role, you think? Because you also mentioned you're a buyer for this technology, you are probably also a target of this technology, and now you're saying you're also like an arbitrator, a monitor function. So
I think that's why we're all here, because despite the efforts of NSO and my office, those who actually use this stuff, hopefully, respectfully, legitimately, there is a global sense that spyware is being used for illegitimate purposes all over the world and in very serious cases. And so it's hard to trust an agency like mine or a company like NSO because we sound like we're doing a good job, but the use of spyware is a $12 billion global industry. It's incorporating a lot of folks who are misusing it. And NSO, and I'm sure it's been criticized for how it used it, and I won't comment on that because I don't know all the details. But my office was criticized for its uses of technology. So where do we go? And we can talk about how to regulate spyware and what are the appropriate ways, and I'll defer to my colleagues if they want to answer that question.
Now, I'll start with that. Where do we go? I think is really the main issue, and this is something that, again, I think this is wonderful that this is a discussion with such an esteemed forum, within the ABA. And I think, I've been with my fast that, maybe the ABA or, might even go and, take this upon it as some type of project, or other type of bodies, that we've been discussing this with the OECD or different UN organizations, etc. Because where we go, as I said before, it's where there is the potential, and I'm talking about NSO, and NSO is being like the poster child for a lot of the misuses, which, by the way, many of them are other companies, but everyone knows NSO, and since we're more transparent, so we take the heat for everyone, and again, it's, we will deal with that separately, but I'm saying but we know what we're doing, and we know what we're trying to do, and we know what we're trying to fix. And I just don't think that the other companies, and you said correctly, this is an enormous industry with all types of players that are also trying to establish themselves in different regimes that are, let's call it, export control, user friendly. They're looking, we see this in different, I don't want to name countries, but it's very, if you look in the web and see, many companies are establishing themselves in some remote locations in which there's very lax export control and selling these tools or similar tools to the worst players out there. And I think where we go from there is to go and think about the balancing, because ultimately it's like in any other legal issue, and that's why we're groups of lawyers and everything. Our whole lives, everything we'd be trained for is balancing. Right, balancing one right against another, balancing one interest of one person against the interest of the collective, etc. Here we have a balance of human rights. Right? We have a balance of the right to privacy and the right for expression, etc. Right, on the other hand, there's the right for safety and the right for human lives. And I don't want my children to be in the situation. My children are now sleeping in the bomb shelters. To be in a situation that they're, kidnapped and beheaded, like, thrown in my neighborhood that it's happening. That's also a human right. It's a basic human right. I think we need to find the right balance between them as far as how this tool should be used, by whom, in what way, who should be regulating it, who should be oversight, what oversight should there be, what is considered a good country or a bad country. We have our parameters according to the different indicators, but maybe some international regimes should go and say only countries that go and fulfill a certain requirements of protection of human rights, etc., are eligible to go and receive such tools, and all export control authorities in all countries must adhere to that under WASANA or some other type of international. So I think there's a lot to be done, and there is a lot should be done, because I think we know better than others what damages these tools can do. So as I said, we're trying as a company, and we get a lot of criticism. Maybe some of it is justified, but a lot of it is, I think we're one company that's really trying to deal with these issues, balance these issues, find the right solutions. But I think that, I kind of feel that we're kind of alone. And I think that this is a great, either my colleagues in the panel and for our audience at OWL and for ABA, etc., to go and think about whether this is something we could have in academia, we could have roundtables, we could have discussions with law enforcement agencies, as well as with civil society, finding the right balances. I think this is really something that should be done, and I just don't think we should just have another panel and say nod our heads and okay, this is another issue, let's move now to a recess and for the next panel. I think this is a serious issue with global implications, and I think it needs to be addressed accordingly.
Right. I agree. I think what we have established so far is there are good uses for this technology, and the problem is how to regulate it, who to regulate it. And I think this is not unique to take the heat away from it. So there are other technical advances that cause some kind of ethical questions, such as cloning, such as, for example, the growing artificial meat, are we playing the role of God? That kind of question comes from in biological fields all the time. So this is, I think I would put that in the same category, except there are some high-profile cases. I guess that's why NSO is taking the heat. Well, let me ask the one, any question from the floor, you were the president before I ask. If not, I'll ask my last question. Any question from the audience? Yes, please.
So I had a question. You're answering something that you were saying in relation to the development of maybe treaties or international responses to a regulation of spyware. Are there actual initiatives and developments that reflect on that are in play and that might lead to something of that nature? Or is it still being done at a governmental level, state by state?
Yeah, briefly, are there any international efforts on this front, ongoing or past or in the future?
Well, there are many, actually. And I think there are now restrictions in the United States, for example, by order of the president on the U.S.'s ability to use spyware in the operation of the government, and that the agencies have to essentially now report out on are they using it, how are they using it. There have been developments in Europe, and there's actually a treaty that's started in 1996 that has 46 countries that are signatories to it, which are an effort to rationalize the proportionality, the terms of use, the severity, and what you use. So I think globally there's actually a lot going on, but it's fragmented, and I think it's like anything else. To get a global treaty around cybercrime, for example, which is analogous, is not in the cards. There are lots of answers why it's not in the cards. The technology develops so quickly that what you worry about today is a different problem tomorrow. Countries are very jealous to guard their ability to operate in this space and don't want to cede their sovereignty around technology and protect themselves. So these are the competing balances of getting agreements on technological advancements, which frankly are pretty much all came about in this generation and are new.
At the international level, the action by state using the spyware to enemy state or the other countries is not regulated, I think. The espionage is the international law, is understand each other countries. But if the spyware make the critical calls to the physical systems, that is the international level, that is regulated by the UN or the other one side. So that is formulated, are under formulating as by Tallinn manual. You would understand that kind of the international level, a cyber attack and the protection of each countries. And then the other one is in the industry or the private sector using the spyware is the crime. So all the countries that is if get the evidence of the crime, they will be punished. So this is the focus on our focus is how the legal body or the investigation body of the government body using the spyware to their government action. That is the regulated. That's the focus on the using the spyware targeting evidence is the narrow, not the whole device, not the whole data they collect. It is the trend. All the countries is focused on the regulated the legislation policies, I think.
So maybe like one, I'm sorry, I'm sorry, and since I don't see you, did you finish or you
Go ahead.
Okay, I wanted to say something as far as international initiatives. The national initiatives are important a lot more than the national level for one main reason. It needs to relate both to the country that uses the tools And I think that, the esteemed professor is talking about, what, let's say in Korea, the rules are for use, but it also should be as far as the export of the tools from a specific country. I think it needs to be dealing with both side A and side B, because I think the international regime should say, okay, all countries should commit themselves that they will not export unless the recipient does A, B, and C. And here you need to have enforcement both on the A and on the B. You need to have the enforcement that, that this is something under international convention. No country will export, to the wrong countries. And the countries that are part of the Bs, the permitted countries or the legitimate countries, etc., will have also their responsibility in such a way that if they do not fulfill it, they'll be stricken off from such convention of permitted countries. I think that's the type of regime that I'm looking for, and I think that's something that on an individual national level it will never be achieved, because also I think it was mentioned before, there's so many national interests. Sometimes governments would think more about their financial interests and say, how come other countries are exporting and we cannot, and etc. So that's why I think it's very important, not to deal with it on a national level, but to deal with it at an international level.
So, to avoid repeating anybody else, I think one compounding factor for all this is the inherent sort of stealthiness or secrecy surrounding both the technology, which I think is largely unnecessary. There's really nothing particularly magical about the technology from my perspective, but its use. And to go back to something that Shmuel said about the safeguards and the contractual provisions that they've put in and so on, this is all great, but I think where people kind of continue having a sort of a reaction to the whole thing is that it's not visible outside, right? So you may be taking all these steps and doing the right thing, but nobody else can tell. So in similar, not identical, but in similar situations or contexts in technology, one first step before regulation or law has been transparency, right? So you're afraid less of something if you know about it, if you can see aspects of it, right? So as a sort of strong suggestion from a technologist here, right, if NSO is doing all these steps and like they say, well, we look at the audits, did you do the right thing, did you do the wrong thing? If you did the wrong thing, we terminate it. Well, how about releasing some of the logs, kind of name and shame the culprits and say, well, you did something that was outside the contract and it was violating, human rights. I'm not saying release everything, but enough to then make the organization, the agency, even the government that misused the facility, the tool, make them kind of stand at the corner or be a pariah in a small of sorts. We've done things like this with other technologies that are difficult to regulate inherently, and we have to rely and trust on their proper use, and when they're misused, we just name and shame, for lack of a better term. So why not do this? I will also add to this, right, another dimension of the sort of contrasting interest. One is, right, sovereignty of nations. To the extent that the country chooses to use or misuse the technology against its own citizens, well, Treaty of Westphalia, many centuries ago, says, well, they get to do it. They're the sovereign country. On the other hand, more recently, we have the right to protect, from the United Nations saying that you have the right to protect fundamental rights, even if they're in another country. So does that mean that those that can should step in and squash the cyber activities of actors that are acting sort of against human rights, fundamental rights, and so on? That kind of seems like it opens a little bit of a Wild West. On the other hand, technologically, that might be the thing that can happen the easiest in the short term. Right? Policy-wise, probably not, but technologically, honestly, it happens anyway in the sort of in the intelligence and cyber war side of things on the internet. So why not just do it for those purposes?
Well,
That's transparency side. I'm not sure I heard the second part. No, the transparency, first of all, we're very much, I think transparency is crucial. But I think you all understand we're dealing here with intelligence agencies, right? The law enforcement agencies, their tools and methods are never published, and that's a problem. It's also part of their, contractual relations with the customers are, of course, keeping secrecy. Now, I do agree that, if a company or a country has kind of misused the system, but, this should be, and I think the governments that are involved, they're familiar with our activities and know what is happening. I don't think that it's proper for us as a private company to be putting shaming on governments when we're even ready to do so contractually. But I do think, and this is again my maybe for the fifth time during this past hour, saying under a regulatory regime, that should be, that should be part of that. I think that part of having some type of oversight of, under a convention. Same thing, it's similar maybe, I don't know, similar, looking at what the OECD is doing in the anti-bribery convention, right? It has the countries that they kind of meet in Paris once a year, and, it talks about enforcement, and they talk about what needs to be enhanced, and talk about which countries are not doing enough. I think that's the type of forum that I'm envisioning, and I think within that, and if there has been a misuse, and I think that's exactly what Angelos is on. I think we're trying to reach the same thing. And as I said before, country A and country B. If there are countries or customers that misuse the system and they shut down the system, etc., I think that under international regime, this is something that should be dealt with between governments and say, okay, this is you have to trust and verify. We trust in you, and yet the verification failed, and as such, you should not be under the permissible countries that are able to go and use such tools, such powerful tools, maybe under suspension for a while, maybe until there's corrective action, maybe until there's more oversight, maybe until there's change of legislation. There's a lot of things that can be discussed on an international level, but as a company, for us, it's kind of binary. Did you go and did you do it, or did you misuse, did you not misuse? If it's a strong misuse, we'll shut down the system. We don't even have a mechanism that I think that's also lacking, because sometimes, if it was a governmental situation and there was transparency, as you say, we can say, okay, this organization needs to be reshuffled until it falls under the legitimate agencies that can use such systems, etc. And I think all of this is lacking, and I'm totally connected with everything that you're saying, that these are issues that should be done. I just don't think that it's fair to put on a software developing company, with a few hundred employees, sitting in Israel to put upon themselves all the global responsibilities of the world. I think that's a bit unfair, and we're doing what we can. I think we're doing a lot more than other companies, but I don't think we're a government. We don't have powers of the government. We have the power of the licensor. To shut down the system or not shut down the system. And I think there should be a lot more than that.
I think that this is a good place to start. We're 10 minutes over time. I know there are other questions. Please approach your panelists after this is break time. Hate to stand between you and the break. Please round of applause for my esteemed panelists. Thank you very much.